Okay, so I welcome you again to this panel. Our topic is the Attorney General powers. I would like to welcome the panelists. I will introduce them in a bit. Now, as you know, the office of the Attorney General is unique in the Cyprus constitutional order, and I often say that the Attorney General is the most powerful person in Cyprus, having more powers than the President of the Republic.
Exaggeration.
Excuse me?
Exaggeration. I don't appoint myself.
I don't think so. The role of the Attorney General is central to the proper functioning of our justice system, not only in Cyprus, but in all democratic societies. The Attorney General is the guardian of the Constitution and the rule of law. He is the legal advisor to the government, and he has uncontrollable prosecutorial discretion. So our panel today will explore the crucial role of the powers of the Attorney General in upholding the rule of law. And we will focus on the prosecutorial discretion, on the judicial oversight, and the challenges of maintaining accountability while preserving the independence of the office. I would like to introduce the panel members. As you know, the Honorable Attorney General, Mr. George Savvides. Mr. Savvides is a lawyer by profession. He's a barrister. He practiced law for 35 years. He served as a Minister of Justice and Public Order of the Republic of Cyprus from May 2019 till June 2020, and in June 2020 he was appointed to the office of the Attorney General by the President of the Republic, Mr. Nikos Anastasiadis, and he will be retiring when?
In
3 years? 4.
22nd of September last week,
Yes.
3 years.
In
so
3 years.
it's 3 years minus 5 days.
Okay. Also, I have the privilege in my right, the ex-Prime Minister of Poland, Mrs. Hanna
Suchocka. Suchocka.
Suchocka.
Yes.
Yes. Mrs. Suchocka has been Prime Minister, the first female Prime Minister of Poland. She served from 1992 to 1993. She's a constitutional law expert. She served as Poland's ambassador to the Holy See between 2001 and 2013. So you are blessed.
To some extent,
Yes.
by 3 popes.
She was one of the founders of a liberal and social democratic liberal union party.
But you have forgotten important my function, that I was Minister of Justice and Attorney General in my career also.
I was about to say
It is probably
yes.
most important now.
Okay, so she was Minister of Justice and Attorney General. The gentleman to the right, Mr. Demetriou, he's an MP, he's President of the Parliamentary Committee on Institutions, Merit and Commissioner on Administration of DISY. Demetris is an electrical and computer engineer and has an MBA in Business Administration. And Mrs. Christina Karakosta, she has a law degree from Athens Law School and a Master's on Human Rights and EU Law. She's a policy officer at the European Commission's Directorate General for Justice in the Rule of Law Unit. She's a country leader for Cyprus and Greece. And prior to that, she served in the European Anti-Fraud Office, the European Ombudsman, and the European Court of Human Rights. Her areas of expertise include fundamental rights, rule of law, administrative law, and the protection of EU financial interests. Okay. Now, in theory, we have 90 minutes. I don't know if we will need all the time. I guess we will. We will have a keynote speech by the Attorney General. It will take 10 minutes. And then we will have a discussion by the panel members based on the issues that I outlined above, and that we will reserve 15 minutes at the end for questions by the audience. So, Mr. Attorney General, your keynote, please.
Thank you, Mr. Moderator.
Is the microphone on?
No.
But you have this one, so it's
Can you hear me? Dear moderator, distinguished panelists, ladies and gentlemen, dear colleagues, I wonder why I was asked to present my keynote speech in Greek, but I was told to do it in Greek, so I hope that those of you who don't speak Greek will be able to follow it through translation. And I will try not to exhaust my 10 minutes, to give more chance to have a more lively discussion at the end of the session. Καταρχάς, θα ήθελα να ευχαριστήσω τους διοργανωτές για την ευγενική τους πρόσκληση να συμμετάσχω ως ομιλητής στο 5ο ετήσιο Cyprus Forum και να μιλήσω για τις εξουσίες του ανεξάρτητου θεσμού που υπηρετώ, του Γενικού Εισαγγελέα της Δημοκρατίας. Οι σημαντικότερες αρμοδιότητες του Γενικού Εισαγγελέα της Δημοκρατίας και ο θεσμικός του ρόλος καθορίζεται στο Σύνταγμα και είναι κομβικός στην άσκηση των 3 εξουσιών του κράτους. Ρόλος που εμπολής διαμορφώθηκε λόγω και του δικοινοτικού χαρακτήρα του Συντάγματος. Όπως αναφέρθηκε πολύ πρόσφατα από το Ανώτατο Συνταγματικό Δικαστήριο, ενεργώντας ως Συμβούλιο, διαχρονικά στην ομολογία των δικαστηρίων μας υποδεικνύεται το ύψιστο του πολιτιακού αξιώματος με το οποίο ενδύεται ο θεσμός του Γενικού Εισαγγελέα και ο κεντρικός ρόλος που του αποδίδεται ως προασπιστή της νομιμότητας και του δημοσίου συμφέροντος. Αυτό είναι από την αίτηση 1 του 2024 για απόλυση του Γενικού Ελεκτή της Δημοκρατίας, ενδιάμεση απόφαση ημερομηνίας 5 του 24. Σύμφωνα με το άρθρο 112 του Συντάγματος, ο Γενικός Εισαγγελέας της Δημοκρατίας και ο βοηθός Γενικός Εισαγγελέας διορίζονται από τον Πρόεδρο της Δημοκρατίας και πρέπει να κατέχουν προσόντα διορισμού δικαστών του Ανωτάτου Δικαστηρίου. Υπηρετούν μέχρι την αφιπηρέτησή τους και δεν παύονται με τη λήξη της θητείας του Προέδρου που τους έχει διορίσει. Προείστανται της νομικής υπηρεσίας, η οποία είναι ανεξάρτητη υπηρεσία, μη υπαγόμενη σε οποιοδήποτε Υπουργείο. Τόσο ο Γενικός όσο και ο βοηθός υπηρετούν με τους ίδιους όρους που υπηρετούν οι δικαστές του Ανωτάτου Δικαστηρίου. Δεν απολύονται παρά μόνο με τον ίδιο τρόπο που απολύονται οι δικαστές του Ανωτάτου Δικαστηρίου. Μέσω δηλαδή αίτησης παύσης ενώπιον του Συμβουλίου, που αποτελείται από τους δικαστές του Ανωτάτου Συνταγματικού Δικαστηρίου για ανάρμοστη συμπεριφορά. Όπως είναι γνωστό, ο Γενικός Εισαγγελέας με βάση το Σύνταγμα έχει 2 πολύ σημαντικές εξουσίες, όπως είπε και ο κ. Χριστοφή. Πρώτον, είναι ο νομικός σύμβουλος της Δημοκρατίας, του Προέδρου της Δημοκρατίας, του Αντιπροέδρου της Δημοκρατίας, του Υπουργικού Συμβουλίου και των Υπουργών. Στο πλαίσιο αυτό γίνεται ο νομοτεχνικός έλεγχος των νομοσχεδίων της κυβέρνησης, παρέχονται γνωμοδοτήσεις προς τα αρμόδια Υπουργεία και τη χάνουν χειρισμού όλες οι δικαστικές υποθέσεις που αφορούν το κράτος, οι αναπομπές, οι αναφορές νομοθεσιών σύμφωνα με τις οδηγίες του Πρόεδρου της Δημοκρατίας και πολλά άλλα. Κατά δεύτερον, ο Γενικός Εισαγγελέας έχει εξουσία κατά την κρίση του προς το δημόσιο συμφέρον να κινεί, να διακόπτει οποιαδήποτε διαδικασία ή να διατάσει δίωξη οποιοδήποτε προσώπου στη δημοκρατία. Συγκεκριμένη πρόνοια του Συντάγματος καθιστά το Γενικό Εισαγγελέα ως τον απόλυτο άρχοντα και υποπτεύοντα όλων των ποινικών διώξεων, κάτι που παγίως έχει νομολογηθεί μέσα από τις αποφάσεις του Ανωτάτου Δικαστηρίου. Είναι σημαντικό να επισημανθεί ότι η εξουσία προώθησης ή αναστολής μιας ποινικής δίωξης δεν υπόκειται σε οποιοδήποτε έλεγχο του δικαστηρίου, της νομοθετικής ή της εκτελεστικής εξουσίας, και αυτό είναι κάτι που επίσης έχει σταθερά διακηρυχθεί στην νομολογία του Ανωτάτου Δικαστηρίου, όπως για παράδειγμα στην απόφαση Πολύς εναντίον Αφιενίτης 1983. Είναι γεγονός ότι τα τελευταία χρόνια ο θεσμός του Γενικού Εισαγγελέα έχει δεχθεί κριτική από πολιτικά πρόσωπα και άλλους και μέσα μαζικής επικοινωνίας, αλλά και απλούς πολίτες, κυρίως λόγω του ανέλεκτου των εξουσιών του. Θα λέγω ότι από κάποιους καλόπιστα, από κάποιους όμως κακόπιστα. Θα ήθελα να διευκρινίσω βέβαια ότι το ανέλεκτο των αποφάσεων του Γενικού Εισαγγελέα δεν συνεπάγεται ότι οι αποφάσεις είτε για ποινική δίωξη είτε για αναστολή ποινικής δίωξης λαμβάνονται αυθαίρετα. Αντίθετα, και θέλω να το τονίσω αυτό, εδράζονται σε θεσμοθετημένα κριτήρια τα οποία συνάδουν με ευρωπαϊκά και διεθνή πρότυπα χειρισμού ποινικών υποθέσεων από διοκτικές αρχές. Δηλαδή δεν αποφασίζει ο Γενικός Εισαγγελέας αυτό θα τον πάρω, αυτό δεν θα τον πάρω. Ακολουθούνται κανόνες, διαδικασίες και κριτήρια τα οποία ακολουθούνται σε άλλες ευρωπαϊκές χώρες, τα οποία έχουμε υιοθετήσει στην νομική υπηρεσία. Πρόσθετα, οι λόγοι που οδηγούν σε απόφαση αναστολής δίωξης ή ακόμα και μη δίωξης καταγράφονται λεπτομερώς στον φάκελο της υπόθεσης. Αυτό ήταν σύσταση της Επιτροπής Γκρέκο και την οποία ακολουθούμε και για την οποία έχει ήδη σημειωθεί η συμμόρφωση της Κυπριακής Δημοκρατίας. Στις πλήστες περιπτώσεις, οι λόγοι αναστολής μιας υπόθεσης αναφέρονται και στο δικαστήριο. Εκτός, βεβαίως, αν εγείρονται θέματα εθνικής ασφάλειας ή δημόσιας τάξης ή άλλοι λόγοι που επιβάλλουν εμπιστευτικό χειρισμό της υπόθεσης, που δεν επιτρέπουν δημόσια ανακοίνωση ενώπιον του δικαστηρίου. Επιπλέον, στα τελευταία χρόνια, για σκοπούς διαφάνειας, σε αρκετές περιπτώσεις, ιδιαίτερα σε σημαντικές υποθέσεις που απασχολούν την κοινή γνώμη, έχουμε προβεί σε ανακοινώσεις λεπτομερείς των λόγων που μας οδήγησαν στην απόφασή μας, στο βαθμό που αυτό ήταν επιτρεπτό από τα δεδομένα της υπόθεσης. Δηλαδή, δεν περιοριζόμαστε στο να το γράψουμε στο φάκελο. Όταν είναι δημοσίου ενδιαφέροντος, βγάζουμε και δημόσιες ανακοινώσεις, τις οποίες επεξηγούμε τους λόγους που μας οδήγησαν στην απόφασή μας. Επιπρόσθετα, μετά από εξέταση των συστάσεων του κράτους δικαίου για το 2023, έχουμε διαμορφώσει ένα πιο εξελιγμένο εσωτερικό μηχανισμό αναθεώρησης, review mechanism, των αποφάσεων που αφορούν σε ποινικές διώξεις. Είναι ενήμερη η Ευρωπαϊκή Επιτροπή για την πρόθεση μας και για τα βήματα που κάναμε. Και δυστυχώς δεν έχουμε προχωρήσει στην εφαρμογή τους, καθώς αναμένουμε να συζητήσουμε τις εξαγγελθήσεις προτάσεις της κυβέρνησης για τις μεταρρυθμίσεις της νομικής υπηρεσίας. Πολύ πρόσφατα μας έχει δοθεί από το αρμόδιο Υπουργείο Δικαιοσύνης μια δέσμη προκαταρκτικών νομοσχεδίων σε σχέση με προτινόμενες μεταρρυθμίσεις που αφορούν στον διαχωρισμό των εξουσιών του Γενικού Εισαγγελέα, στη δημιουργία ενός νέου θεσμού του Γενικού Δημόσιου Κατήγορου και στον δικαστικό έλεγχο της ορθής εφαρμογής των κριτηρίων για προώθηση ή αναστολή ποινικής δίωξης. Αντιλαμβάνεστε ότι ενώ εκκρεμεί πρόταση για δικαστικό έλεγχο των αποφάσεων του Γενικού Εισαγγελέα, δεν θα είχε νόημα να βγαίναμε εμείς και να ανακοινώναμε τον ιεραρχικό έλεγχο, το οποίο ήταν στις περσινές συστάσεις του Rule of Law. Είναι γεγονός ότι τα τελευταία χρόνια έχουμε δεχθεί συστάσεις τόσο από την Επιτροπή Γκρέκο όσο και από την Ευρωπαϊκή Επιτροπή στο πλαίσιο των εκθέσεων για το κράτος δικαίου για την ενίσχυση της ανεξαρτησίας των εισαγγελικών εξουσιών. Υπενθυμίζω ότι η σημερινή κυβέρνηση την Άνοιξη του 2023 ενέκρινε και απέστειλε στη Βουλή νομοσχέδιο για την αυτονόμηση της νομικής υπηρεσίας, γεγονός το οποίο η Επιτροπή Γκρέκο επιδοκίμασε, αναβαθμίζοντας τη συμμόρφωση της Κύπρου με τη συγκεκριμένη σύσταση σε μερικώς υλοποιηθήσα από μη υλοποιηθήσα. Το υποαναφορά νομοσχέδιο δεν έχει μέχρι σήμερα εξεταστεί κατά άρθρο από την αρμόδια Κοινοβουλευτική Επιτροπή. Το θέμα του διαχωρισμού, κυρίες και κύριοι, έχει απασχολήσει την υπηρεσία μας και έχουν μελετηθεί διάφορα συστήματα άλλων χωρών του κοινοδικαίου σε σχέση με το καθεστώς, εξουσίες, τρόπο διορισμού κλπ. Του Γενικού Εισαγγελέα και του Director of Public Prosecutions ή αντίστοιχου, όπως είναι η Αγγλία, η Ιρλανδία, η Αυστραλία, ο Καναδάς, η Μάλτα. Η μεταρρύθμιση που προωθεί η κυβέρνηση, η οποία μεταξύ άλλων προϋποθέτει τροποποίηση πολύ σημαντικών άρθρων του Συντάγματος, είναι δύσκολη, πολυδιάστατη και βαρύνουσας σημασίας. Εξαιρετικής σημασίας είναι και η τεκμηρίωση της εφαρμογής του δικαίου της ανάγκης όσον αφορά την τροποποίηση μη θεμελιωδών διατάξεων του Συντάγματος, αλλά ακόμα και η εξέταση της επίδρασης που θα έχει μια τέτοια τροποποίηση και σε θεμελιώδεις διατάξεις, αυτές δηλαδή που αφορούν το δικοινοτικό χαρακτήρα του Συντάγματος μας. Και βέβαια υπάρχει και το εθνικό ζήτημα, το οποίο παραμένει ανοιχτό, δυστυχώς, αλλά για ευνόητους λόγους δεν θα ήθελα να τοποθετηθώ στο πλαίσιο της παρούσας τοποθέτησής μου. Συνεπώς, η οποιαδήποτε μεταρρύθμιση του μεγέθους που έχει εξαγγείλει η κυβέρνηση θα πρέπει να προσεγγιστεί με τη δέουσα σοβαρότητα και να τύχει ενδελεχούς και προσεκτικής μελέτης. Όχι μόνο από το αρμόδιο Υπουργείο και την νομική υπηρεσία, αλλά και από άλλους επιφανείς συνταγματολόγους στο πλαίσιο μιας διευρυμένης δεξαμενής σκέψης. Αντιλαμβάνεστε, το να κάνουμε μια αλλαγή χωρίς να είμαστε βέβαιοι ότι συνάδει με τα συνταγματικά πρότυπα και αξίες και αποφάσεις δικαστηρίων, θα διατρέξουμε τον κίνδυνο, αν κάποτε αμφισβητηθεί αυτή η αλλαγή, σε μια ενδεχομένως ποινική διαδικασία την οποία θα ξεκινήσει ο νέος δημόσιος κατήγορος, να κρίνουν τα δικαστήρια ότι ήταν μια αλλαγή η οποία δεν μπορούσε να γίνει, γιατί δεν ενέπιπτε μέσα στους κανόνες που όρισαν τα δικαστήρια για τις αλλαγές του δικαίου της ανάγκης, ή άπτεται ή επηρεάζει έμμεσα θεμελιώδη άρθρα του Συντάγματος, άρα δεν μπορεί με τίποτα να τροποποιηθεί, και να βρεθούμε σε μια πολύ δύσκολη θέση να πρέπει να ξαναεπαναφέρουμε μια κατάσταση την οποία θα έχουμε διαχωρίσει μετά από πάρα πολύ μελέτη και πάρα πολύ σκοπό. Πάρα πολύ κόπο και δυσκολία. Με αυτά τα λόγια θα κλείσω, θα το περιορίσω εδώ, θα δώσω χρόνο για περισσότερη συζήτηση. Δεν τοποθετούμε αυτή τη στιγμή, όπως δεν έχω τοποθετηθεί δημόσια, για το αν είμαι υπέρ ή εναντίον επί της ουσίας. Δεν είναι αυτό το θέμα. Και εύχομαι και είμαι βέβαιος ότι θα έχουμε την δυνατότητα να συζητήσουμε το θέμα στη συνέχεια με τους εκλεκτούς κυρίες και κυρίους που συμμετέχουν στο πάνελ. Ευχαριστώ πάρα πολύ.
Thank you, Mr. Attorney General. So let's start the discussion with this, with the dual role of the Attorney General in the Cyprus legal system, and I will give the floor to all panelists to say their opinion about this. I suggest 4 to 5 minutes each, and I will start with the Prime Minister here, and if you could share the situation in Poland. In Poland, how does the Office of the Attorney General work? Does it have a dual role? Is it independent?
Thank you. But first of all, I would like to say that I am invited here as a representative of the Venice Commission, yes? So not as a representative of Poland. So this is a different topic, because I thought that, of course, Poland is one of the examples. But first of all, probably we have to concentrate on the guidelines and the rules which are prepared by the Venice Commission. And in this situation, I don't know, what is now your question to me? Would you like to...
No, I mean, if you could spend a few minutes to tell us the status of Poland very quickly, and
2 minutes for Poland is too short, yes.
Okay.
You know,
let's
it
go
is
to
exactly
the, let's
very
go to
long
the Venice
history.
Commission, then.
I think that history of Polish prosecutor office is even much longer than in Cyprus.
Yes.
And when we start with Poland, I would like to say only some words on the history of the institution, because it is very important for knowing better what we face now in the Polish stage, yes? So I try to keep 5 minutes. If it will be 6, you allow me, yes, to say something. And so, you know, I don't like, of course, to go back to the communist system, when we had a prosecutor office which was built as a Soviet prokuratura. But the institution, Soviet prokuratura, was very important as a, how to say, certain symbol we would like to change when we introduced our transformations in 1989, because we amended very shortly, because of course I have to make the long story short, in the December 1989, we made amendment to our constitution, to the Polish, first in April and then in December, and then we would like to introduce to our system such a model which has nothing to do with the previous Soviet Prokuratura.
Okay.
And you know, it is a consequence what we have now in our system, paradoxically, because in the Soviet system, the prosecutor office was completely independent, yes, independent in the term of communist system. It was independent from the court and formally independent from the executive power, yes, because it was separate pillar in the system of states organs. And then we would like in Poland to build our system of prosecutor office on the model we had before the Second World War, so when we were a democratic state. And for that reason, we decided that we will follow the model, our historical model, where the Minister of Justice played also the role of the Prosecutor General. And it was the situation, it was the proposal, it was done in December 1989, Minister of Justice as a Prosecutor General. It was, of course, a long argumentations why that you would like to have a prosecutor to be taken under certain control, because in the communist system, it was, how to say, over all the powers, despite should be on the same level, yes? Mm-hmm. So for that reason, we look for some barriers for the prosecutor office, and in our opinion, I am using the term our because I was at that time also a member of the Constitutional Committee in the Parliament, and I was also rapporteur of this amendment to the Constitution in December 1989. And I was fully convinced then that the situation when prosecutor, Minister of Justice played also a function of the Prosecutor General is a good solution. Because then the Minister of Justice is under control, parliamentary control, and so for that reason it was for us, how to say, good proposal for the future. But it has happened, but then the reform, I can say, was not finished. Because we did the first step only. Prosecutor General, Minister of Justice, but then it should be reorganized also on the lower level. And the lower level, it was not so consequently followed the system from this situation. Mm-hmm. And then we could observe situations that the function of Minister of Justice in certain situations was exactly completely played in political role, and at the same time also Prosecutor General. Yes. And having, I don't know how it is exactly practiced in the Cyprus system, but in our system, Minister of Justice was of course a representative of the political party, and at the same time he was a Prosecutor General, but it should not be a prosecutor as a profession, because being a Minister of Justice,
every time the government changes.
Yes, because even now, yes, because it's the situation that, for example, when I was a Minister of Justice, as I said, I was also Prosecutor General, but as a profession, I am not a prosecutor. Yes. I am a lawyer, yes, but not a prosecutor. Yes. Okay. But for that reason, then we looked for the solution that it should be also on the high level another person who is a professional prosecutor. Okay. And we have two institutions. Mm-hmm. It is so complicated. Prosecutor General as a Minister of Justice, and then State Prosecutor as a professional prosecutor on the same level, yes? Right. And he was responsible for the procedure in the court. Okay. So, it's only for the moment I mixed up.
Okay, thank you. And we will talk about the Venice Commission later. So,
yes.
Go to Demetris. What is your reaction to what you heard from the Attorney General, who expressed some thoughts and skepticism about the proposed changes? And a couple of questions. Have you seen the government proposed changes? Are you aware of the content? And what is your reaction to that?
Ευχαριστώ, Χριστόφορε. Επιτρέψτε μου να τοποθετηθώ στα ελληνικά. Όχι, δεν είδαμε σε λεπτομέρεια τις εξαγγελίες της Προεδρίας. Ο Υπουργός της Δικαιοσύνης ήταν στην Επιτροπή Θεσμών την ημέρα που το Υπουργικό Συμβούλιο ανακοίνωσε το πλέγμα των νομοθεσιών, αλλά σε λεπτομέρεια δεν είδαμε κάτι και αυτό ήταν και ένα σημείο κριτικής, αν θέλεις, προς την Προεδρία και προς την Υπουργό Δικαιοσύνης, ότι ας έρθουν με συγκεκριμένα κείμενα. Επί της αρχής όμως συμφωνούμε και για την ανάγκη μεταρρύθμισης του Γενικού Εισαγγελέα και τον διαχωρισμό των εξουσιών και για την ανάγκη μεταρρύθμισης του άλλου θεσμού, του Γενικού Ελεγκτή. Άλλωστε, προεκλογικά, το 2022-2023, σχεδόν όλοι οι υποψήφοι αναφέρθηκαν στην αναγκαιότητα διαχωρισμού των εξουσιών. Και ο πρόεδρος Χριστοδουλίδης, και ο Αβέροφ Νεοφύτου, και ο Ανδρέας Μαυρογιάννης, και ο Αχιλλέας Δημητριάδης, και ο Κώστας Χριστοφίδης. Η έκθεση Γκρέκο το αναφέρει. Βεβαίως, ο έντιμος Γενικός Εισαγγελέας κάνει μια άλλη ανάγνωση της έκθεσης της Γκρέκο και το ανέφερε από το βήμα της Βουλής, ότι κακώς συμβούλευσαν τον Πρόεδρο της Δημοκρατίας ότι η έκθεση Γκρέκο αυτό λέει. Η έκθεση της Γκρέκο μιλά για αυτονόμηση της νομικής υπηρεσίας. Όντως, μιλά και για αυτονόμηση της νομικής υπηρεσίας. Εν πάση περιπτώσει, οι εκθέσεις για το κράτος δικαίου και του 23, ειδικά όμως η τελευταία του 24, αυτή που εκδόθηκε τον Ιούλιο του 24, κάνει ρητή αναφορά και ο ρητή νομίζω δεν έγινε ποτέ για την αναγκαιότητα διαχωρισμού των εξουσιών και την αναγκαιότητα δικαστικού ελέγχου των αποφάσεων είτε του Γενικού Εισαγγελέα είτε του Δημόσιου Κατήγορου. Μάλιστα, βάζει σε αμφιβολία με έναν τρόπο, όπως πολύ καλά τα γράφουν στις Βρυξέλλες, κατά πόσον η προσέγγιση της νομικής υπηρεσίας για ιεραρχικό έλεγχο θα μπορεί να είναι αποτελεσματικός. Δεδομένου ότι θα έρθουν οι υφιστάμενοι να αμφιβάλλουν, να θέσουν ένα αμφιβόλο την απόφαση του προϊσταμένου. Εν πάση περιπτώσει, ως Κοινοβούλιο, να θυμίσω ότι τον Φλεβάρι του 2024, 8 βουλευτές υποβάλαμε πρόταση νόμου για συνταγματική τροποποίηση για να γίνει ο διαχωρισμός. Προφανώς η Βουλή δεν μπορεί να κάνει από μόνη της τον διαχωρισμό, διότι θα προκύψουν ζητήματα της συνταγματικότητας με την αύξηση του προϋπολογισμού κτλ. Αλλά μπορεί να δώσει την πολιτική βούληση. Και η αλλαγή του άρθρου 113, που δεν είναι θεμελιώδες, αυτό επιτάσσει. Και αυτή είναι η πολιτική βούληση του Κοινοβούλου για την δημιουργία μιας ανεξάρτητης υπηρεσίας δημόσιων κατηγόρων. Επίσης, ολοκληρώνω σε ένα λεπτό, έχει σημασία και η θητεία, ο περιορισμός της θητείας. Θεωρώ πως αν γίνει ο διαχωρισμός που πρέπει να γίνει, ο νομικός σύμβουλος του Πρόεδρου της Δημοκρατίας φαντάζομαι θα έχει θητεία 5 ετή μαζί με τον Πρόεδρο της Δημοκρατίας και ο δημόσιος κατήγορος, η προσέγγιση των 9 ετών που ακούστηκε, μιας θητείας 9 ετών, όπως και του Γενικού Ελεγκτή, θεωρώ πως είναι μια σωστή προσέγγιση για επίλυση του ζητήματος. Και κλείνω την πρώτη μου τοποθέτηση, αγαπητέ Χριστόφορε, με ένα γενικότερο σχόλιο στα όσα είπε ο έντιμος Γενικός Εισαγγελέας. Είναι με πολύ προβληματισμό που άκουσα την τοποθέτησή του. Αν τη συνδυάσω με την τοποθέτηση για την έκθεση της Γκρέκο, καταλήγω προσωπικά στο συμπέρασμα ότι δεν είναι υπέρ της αλλαγής της μεταρρύθμισης, κατανοητό, δεχτό, αλλά δύσκολη, πολυδιάσταση, βαρύνουσα σημασίας, να δούμε το δίκαιο της ανάγκης, να γίνουν μελέτες κτλ. Θεωρώ πως είναι ένα ένδυμα της προσέγγισης ότι είναι πολύ προβληματισμένος και το λέω με πολύ σεβασμό, είναι η άποψή του, βεβαίως.
Θα ακούσουμε το σχόλιο του μετά, του Γενικού. Χριστίνα, let's talk about the rule of law report and enlighten us what it provides in relation to this dual role.
Yes, since Mr. Demetriou referred to the report, Let me first clarify the nature of this report, because there might be some misunderstanding. So this report is a preventive tool established by the Commission to allow to detect problems at an early stage, problems regarding the rule of law in the member states, and either prevent them from emerging or from deteriorating. So our goal is to help member states enhance the rule of law. And it's in this context that since 2020, the European Commission publishes the report, and since 2022 addresses recommendations to member states. So in the 2023 report, the Commission issued a recommendation to Cyprus to strengthen the independence and the accountability of the law office. This recommendation was repeated last July in the 2024 report, and the content of the recommendation is in essence the same, but it takes into consideration the progress that Cyprus has made during the reporting period, and also tries to clarify the recommendation. And I will come to the recommendations in a second. Another thing that needs to be very carefully addressed is that the recommendations are not standalone. They are always done in relation to the problems or the concerns identified in the report. So if we want to understand the recommendation, we need to read what is in the corresponding part of the report. So regarding the Office of the Attorney General, what the Commission has assessed was, from one part, the issue of independence, and this is linked to the dual role, that assessing under the light of European standards. And what we mean by European standards, the Commission takes into consideration EU law, the case law of the European courts, both the Luxembourg court and the Strasbourg court, and the different opinions and recommendations by different bodies of the Council of Europe that have a remarkable work in the area of rule of law, the Venice Commission having a prominent place in this. So taking into consideration these European standards, we consider that there is an issue and the independence of the law office needs to be strengthened. Again, to clarify that, as I said, this is a preventive tool, so we didn't say that the law office doesn't work properly. We just identified this as a concern that needs to be addressed in order to reinforce the rule of law in Cyprus. And this was also, we have also taken into consideration the Greco recommendation, and had also assessed the draft legislation that is still pending before Parliament. But we consider that this is not sufficient to address the issue that we have identified. Okay. This recommendation was assessed as having some kind of progress in 2024, taking into consideration the draft bill that is being prepared by the government.
So let me clarify this point, because in the report I read that there is some improvement on this matter. It's because of the proposals of the government alone.
Yes.
Nothing else happened, but the fact that the government came up with this package of for amendments is the positive.
Well, we took into consideration also other elements. We took into consideration that following our recommendation, or in parallel, a public dialogue had started. There was a proposal submitted in Parliament by some members of Parliament. So, as I said before, the rule of law report is a preventive tool, and one of its objectives is also to start a public debate in the countries that could lead to progress, developments, reforms. And this actually is happening in Cyprus. So it's the issue is debated publicly at an institutional level, political level, legal, between legal scholars. So these all were taken into consideration. And we are, of course, we haven't seen the details as well of either of the proposal, but this is something that we are looking forward to, and we will, of course, assess the situation in the next cycle of the report.
All right, thank you. Before going to the Attorney General, Demetris, the 9 MPs are across all political parties? Or...
Από πολλά κόμματα, από το Δημοκρατικό Συναγερμό είμαι εγώ και η κυρία Σούπερμαν, από το ΑΚΕΛ η κυρία Χαραλαμπίδου, από το ΔΙΚΟ ο κύριος Μιλωνάς, η κυρία Ταλίδου, ο κύριος Θεοπέμπτου από τους οικολόγους και ο κύριος Παπαδούρης, ο Κωστής Ευσταθίου, μεμονωμένος σοσιαλιστής βουλευτής, ναι. Είναι από μια, αν θέλετε, οριζόντια κοινοβουλευτική αντιπροσώπευση που υπογράφουμε αυτή την πρόταση που βεβαίως δεν ετέθη προς συζήτηση ακόμα στην Επιτροπή Νομικών. Αντιλαμβάνομαι πως θα υπάρχει μια προσέγγιση αναμονής
για να δείτε τι θα γίνει με το κυβερνητικό νομοσχέδιο.
Με το πλέγμα των νομοσχεδίων της κυβέρνησης.
Κύριε Γενικέ, τα σχόλια σας.
Thank you very much. Quite a few points I need to address. First of all, Ms. Karakosta, you mentioned that the partial improvement was in relation to the fact that the bill has been brought by the government. With all respect, the recommendation you had in 2023 was in relation to the control of the decision of the Attorney General not to prosecute. And you put two alternatives in 2023, whether you could do the hierarchical or the judicial. And I was under the impression that the partial improvement was stemming from the fact that our office, being absolutely responsive to what you wrote and recommended in 2023, we went ahead and prepared very detailed rules of hierarchical review, and I think that was what was noted in the report of 2024 as being partial improvement, because in 2023 we did not have a clear recommendation for separation of the dual role.
If I may say, you are not wrong, but I'm also not wrong. So
I'm
both,
not saying you're wrong.
No, both are actually valid, because the recommendation for Cyprus, both years, had two components. One having to do with the independence, and that was linked to the dual role, and the other component had to do with the accountability, and that was linked to the lack of review. And if one reads the report, they will see that there are two paragraphs, one assessing one part and the second paragraph assessing the second component. And, but the question was asked before was about the dual role, that's why I only replied to this part. If I can say a few words about the issue of the review. So the second component had to do with the lack of a review of the decisions not to prosecute or to stay proceedings. And in that respect, also taking into account European standards and the fact that until then Cyprus was the only member state that there was no review at all, we asked Cyprus to introduce a review. In our recommendation, we did not ask for a judicial review or an hierarchical review. We asked for a review. And in the assessment of the recommendation for 2024, we found some progress, limited though, that's what exactly we used as an expression in the report, taking into consideration the efforts made by the law office to introduce a review.
We will discuss this separately.
Okay.
Attorney General, can you, your comments, and also if you can comment on Demetris' remark that from what you said in your keynote, he assumes that you disagree. Yes.
Mr. Piggy, you want to hear this?
She's going to go.
There is some great anxiety by members of parliament who want to put words in my mouth. And I hear a lot from members of parliament as to what it is that we as the current leadership of the law office want or do not want. We have never publicly taken a position on whether we're in favor or against the separation. There are arguments both ways. Let me explain what the process is so as to finish with this. Yes, I did mention, and Demetris is right, I did mention that my reading of the Greco report, coupled with the reviews and the rounds of further discussions, that they never spoke of separation, even though some members of parliament insist that it did. And I'm happy to go through and have a special discussion on this, although it's no longer relevant because now the separation is an issue that comes up in the rule of law, which is, in my view, more binding in a way than the Greco report.
Yes.
Without saying that anybody can not take into account seriously the Greco report.
Yes.
And in fact, as a law office, we have complied with all Greco reports. So there are three processes that we have to go through, and it's important that we have to go through these processes before we actually decide. And let me make this clear. I have never signified publicly that I am against separation. And let me clarify, even if there is a bill for separation, it is clear that it will not and it cannot affect the current Attorney General.
Yes.
So I have no...
You have no personal interest in this.
Personal interest, so to
Yes.
speak. I cannot be challenged as if I have a personal interest.
Yes. Yes.
So taking this out of the way,
He's
Taking the
I feel
microphone.
Yes,
I'm
he's
on
taking.
an electric
Exactly.
chair.
Yes, exactly.
I have never been so wired in my life.
I think you were.
You think so?
Yes.
You may know better. I try to keep my ears shut. So, let me clarify the process as I see it. I see it as a three-stage,
Couple of minutes.
as a three-stage process. The first stage of the process is what changes do we want to achieve? This is a political, it's a legal, it's a parliamentary discussion, it's an executive discussion, and I think that, as Demetris pointed out, there is quite a consensus as to what the politicians, the executive and the legislature and the rule of law seem to want.
Yes.
So we go through the stage one. I'm not going to discuss stage one at this stage for the reasons I have explained.
Yes.
The second stage is everybody has to understand that Cyprus is not like Malta, where the Venice Commission went there and they said, we don't like this, we need to separate Attorney General, legal advisor, and so on. Change the constitution. They changed the constitution, no problem. They started afresh, turning the page, and have two separate officials. So the second process, which is much more important than the first, is to have experts, constitutional experts, dealing with the constitutional challenges we're facing, so as to put into place our wishes, which is stage one, and we have to have a very, very important discussion and a very serious discussion to decide what it is, out of what it is that we want to achieve, what of this can we filter through the very rigid and bicommunal constitution we have. This is my concern. It's not whether we will have one or two persons or two or four. This is not the big issue. The big issue is not to do anything which might create much more serious problems than what we're trying to solve.
Yes, and there is the political aspect as well.
Yes, that's true. And the third, and I repeat, we are living in a divided country with a constitution which has been our flag for maintaining the country for so many years. We have to be careful before this will be the greatest ever reform made to our constitution. We have to consider it carefully. So, second process is filter our wishes through the constitutional restraints. And through that, we get to the third process. Out of what we want, having filtered it through the Constitution, what is it that we can achieve?
Okay.
And this is what we have to do.
Okay. Prime Minister, as a member of the Venice Commission, what is your take on this, on the dual role?
As you know, sitting here and listening to the discussion, sometimes today I feel myself like a rapporteur to the Cyprus, yes? Because normally, as we are appointed as a rapporteur, we are going to the country and we have a discussion with all the stakeholders. And being here, I have a privilege, listen to your discussion, yes? What are the main controversies? And then after all the controversies have been explained, we have to prepare our report. But today I am not making the report, but I feel myself like in this situation because I don't like enter into the internal discussion concerning Cyprus, because being a rapporteur, I should be independent, as prosecutor should be. Yes, so for that reason, I am independent and I would like to analyze the situation. I can say, from the point of view of the Venice Commission, that, and we know it very well, that the Venice Commission always was of the opinion that as concerns the prosecutor office, there are possibilities of the two options, yes? That prosecutor could be a part or executive power, or it could be part of judiciary, even or completely independent. There are three different models. And it was strongly supported by the Venice Commission in the beginning, and in the report of the Venice Commission, which has been prepared, the famous report, Guidelines on the Prosecutor Office, on the judiciary, but second part is on the Prosecutor Office. It is a report from 2010. The date is very important, because till 2010, the Venice Commission was, I can say, much more open for existence of two or even three different models. And then 2010 is a certain starting point in certain countries when the judiciary, it's the first step, but the judiciary is taken under a certain political control. The first country was Hungary, yes? And then it was a sign for the Venice Commission, okay, we have to observe much deeper the situation, because we exactly allow to organization of the prosecutor office in different way, but it is taken by politicians to be, fulfilled in a totally instrumental way. And now I can say that still Venice Commission still is of the opinion that there is no single unique model for the prosecutor system in different countries, but they should be preserved certain rules. And then it is also very strongly now, Venice Commission very strongly now is pointed out on the independence, or better is to say autonomy of the prosecutor office. Because Venice Commission is always making, it is in all the opinions, and even in general report, the differences between independence of judges and judiciary and independence of the prosecutor office, because it's not on the same level. Independence of the prosecutor is always, I can say, less independent, yes? Okay. Because as we discuss here, you discuss here, there is also this hierarchical system in the prosecutor office, and it should be, because we should not eliminate completely the hierarchical subordination of the prosecutor office, which does not exist in the judiciary, yes? So for that reason, the Venice Commission is now much more concentrated on the independence of the prosecutor office, guarantee of the independence, and so for that reason, in the last opinions of the Venice Commission, there's much stronger supported the idea to separate the prosecutor office from executive power. Yes. It is very strongly now done in the opinion to Polish system, yes? I started with the Polish system, where we have the combination. Then since 2009 till 2016, it was a separation, but also unfinished. Okay. And now we have again the separation. A new Minister of Justice, now he prepared a new draft where he proposed the strict, separation between Minister of Justice as a political minister and Prosecutor General. But I also would like to take your attention, that when we accepted our model, we decided not to regulate the prosecutor office in the constitution. When you take the Polish constitution, you
There
don't
is no
find
provision?
no, nothing, no provision prosecutor office, because it was this argumentation. When Minister of Justice is a prosecutor general, and we don't have in the constitution the part on the individual ministries, so of course, why we have to regulate prosecutor general? But now, when the Minister of Justice proposed the new law on the separation, we have to also prepare a special amendment to the Constitution, yes? How the power of the prosecutor will go on. But it is a new proposal, and the discussion on the new amendments to the Polish law will take part now in the next week during the meeting commission. But I only would like to support that we are using here the term standards concerning the prosecutor office. It's much more difficult exactly to elaborate the standards for prosecutor office, which are so common as there are in the judiciary, yes, to the judges. So for that reason, the discussion is much more, how to say, emotional, and sometimes all arguments are, how to say, acceptable. But then finally, it should be given a certain place, and very important, for the independence of the individual prosecutor. Because here is a problem, how far we can give guarantee to individual prosecutor, not only to, how to say, fulfill the political will of the prosecutor general. It is one of the crucial problems, how we have to accept this now. Yeah?
Okay.
So,
thank you,
very
Prime
short.
Minister. Yeah. I want to move to the second issue, Demetris, which is that of the uncontrollable prosecutorial powers of the Attorney General. Which was repeated very recently in the judgment of the Council in the Auditor's General petition. The court repeated the principle that the power of the Attorney General to initiate or stop criminal proceedings cannot be and is not controllable. So we have this second issue to comment.
Λοιπόν, το πρώτο που θέλω να πω είναι να συμφωνήσω μαζί σου ότι όντως ο πιο ισχυρός άνθρωπος στην Κύπρο είναι ο Γενικός Εισαγγελέας.
Ναι.
Ζούμε σε μια χώρα που δυστυχώς δεν είναι φυσιολογική. Δεν υπάρχουν θεσμικά αντίβαρα, δεν υπάρχουν check and balances. Ο πρόεδρος της Δημοκρατίας λειτουργεί ως άλλος αυτοκράτορας, μπορεί να διορίσει όποιον θέλει, όποτε θέλει. Και ο Γενικός Εισαγγελέας...
Όταν είναι στην Κύπρο. Όταν είναι στην Κύπρο.
Όταν είναι στην Κύπρο. Και ο Γενικός Εισαγγελέας, ο εκάστοτε, μπορεί με το ανέλεγκτο να σταματήσει, να διώξει, ούτω καθεξής. Δεν λέω ότι γίνεται χωρίς αιτιολόγηση ή γίνεται χωρίς, όπως το ανέφερε και ο Γενικός Εισαγγελέας προηγουμένως στην τοποθέτηση του, χωρίς λογική. Αλλά έχει αυτή την εξουσία. Και να σας πω και κάτι. Αν θα διαχωρίσουμε τον ρόλο του Γενικού Εισαγγελέα από τον δημόσιο κατήγορο, από τον νομικό σύμβολο των δημόσιων κατήγορων και να μην υπάρχει έλεγχος, θα κάνουμε μισές δουλειές. Τώρα, είπα προηγουμένως για τον περιορισμό, για τον προβληματισμό, το πρόβλημα αν ο έλεγχος θα γίνεται ιεραρχικά. Αντιλαμβάνομαι, κύριε Γενική Εισαγγελέα, από την αρχική σας τοποθέτηση ότι η πρόθεση της κυβέρνησης, φαντάζομαι ξέρετε λίγο περισσότερο από εμάς, είναι αυτός ο έλεγχος να είναι δικαστικός. Και αυτό θα είναι θετικό. Όμως...
Μα θα είναι θετικό, να το δούμε να θέλει.
Σε μια αντίληψη ορθολογισμού, λέω, δεδομένου ότι σεβόμαστε τα δικαστήρια. Αν πούμε ότι δεν σεβόμαστε τα δικαστήρια και θα μπορεί αυτή η εξουσία να είναι εκ του περισσού, να το συζητήσουμε. Όμως, θέλω να σχολιάσω λίγο το δεύτερο στάδιο της προσέγγισης του Γενικού Εισαγγελέα, που συμφωνώ. Το δίκαιο της ανάγκης, το οποίο σωστά εισήχθηκε το 1964, πριν ακριβώς 60 χρόνια, ως προσωρινό μέτρο, μας περιορίζει και πάλι. Δεν λέω να το αγνοήσουμε, δεν λέω να μην το λάβουμε υπόψη, δεν λέω να διαγράψουμε και να θέσουμε ένα αμφιβόλο και σε κίνδυνο την Κυπριακή Δημοκρατία, αλλά αν υπάρχει η πολιτική βούληση να το κάνουμε, θεωρώ πως θα πρέπει να βρούμε τους συνταγματικά ορθούς τρόπους, τους νομικά ορθούς τρόπους, να προσπεράσουμε αυτά τα σημεία και να προχωρήσουμε σε αυτήν την μεταρρύθμιση. Και κάτι τελευταίο. Γίνεται πολλής λόγος για την εμπιστοσύνη του κόσμου, των πολιτών προς τους θεσμούς. Και είναι όντως κέρια η συζήτηση. Και θα πρέπει να την κάνουμε. Θεωρώ πως και να κάνουμε όλες αυτές τις μεταρρυθμίσεις, δεν θα λύσουμε στον πυρήνα, στη ρίζα, αυτόν το πρόβλημα, που είναι κυρίαρχο πρόβλημα. Την εμπιστοσύνη των πολιτών θα την κερδίσουμε ξανά όταν, κατά την άποψή μου, ξεκινήσουμε να μιλούμε με λίγη περισσότερη ειλικρίνεια. Σε ό,τι κάνουμε. Και όπως και αν κάνουμε, και δεν λέω ότι σε αυτόν το πάνελ δεν γίνεται με αυτόν τον τρόπο η συζήτηση. Μιλώ γενικότερα στην πολιτική συζήτηση και στην πολιτική ατζέντα όπως τίθεται κάτω. Ως εκ τούτου, κλείνοντας, θέλω να πω πως καλές οι μεταρρυθμίσεις πρέπει να γίνουν, θα πρέπει να βρούμε τους τρόπους να διαχωρίσουμε τον ρόλο του Γενικού Εισαγγελέα, θα πρέπει να βρούμε τους τρόπους, τον τρόπο να υπάρχει ο έλεγχος των αποφάσεων, γιατί δεν είμαστε στο 60, όπως και να το κάνουμε. Υπάρχουν υποθέσεις οι οποίες αφορούν την κοινή γνώμη, υπάρχουν υποθέσεις οι οποίες έχουν ενδιαφέρον, θα πρέπει να βρούμε τον τρόπο να γίνεται σωστά.
Christina, rule of law and prosecutorial powers.
So, the question of accountability.
Yes.
Yes, so, as I said before, the Commission recommended to introduce a review without specifying whether this review should be judicial or hierarchical. We need to take, of course, into consideration two things. The first one is that whatever the review chosen will be, needs to be effective and meaningful. So introducing a review just to say, to tick a box that we have introduced a review, this is of course not enough. So it needs to be an effective review. Now, we also need to take into consideration that, of course, in some countries, not all countries in the EU have a judicial review.
Judicial review?
Yes, not all countries.
Okay.
There are countries that have only this internal hierarchical review, and I will give the most, let's say, characteristic example is the Scandinavian countries. But we also need to take into consideration how the prosecution is actually structured and organized in these countries, because
the judicial review relates to a decision of the Attorney General to give nolle prosequi, for example, or whether to initiate prosecution as well?
Both.
Both?
Both. And I think, because of course, a decision to prosecute then will lead to further steps and will eventually go to court, and then this can be challenged in court. But it's the decision not to prosecute that is the final one, and doesn't have any further step that poses,
so you can go
creates
to
the question.
court, challenge this, and the court may annul the decision of the Attorney General and order prosecution?
Yes, if there is a judicial review. And also an hierarchical review. So in the Scandinavian countries, there are 3 levels of prosecution. Let's say first instant appeal, and then the general prosecutor.
But
each
this
level
is never ending. I mean, don't you need finality in these things?
Never ending? What do you mean?
If you challenge the decision, you go through the court system, takes time.
But this is also, with this logic, also all the legal remedies that we have in all different commercial, civil, there is a never ending if you don't have, the reason we have different stages and appeals is to, let's say, remedy mistakes or over, that has happened before. And there are, of course, rules. The fact that there is a review doesn't mean that you can review everything. There can be rules as to what
Does
can...
it depend on the type of the offense as well, or the years of imprisonment?
I mean,
if it's a serious
I'm
offense?
not an expert on the review on, prosecutorial decisions, but what I can tell is that when you create the system, you can have conditions.
And checks and balances within the
Of
system.
course,
Yes.
so
Okay.
there can be conditions, who can introduce the review, and how the deadlines, what are the conditions, what can that person challenge, etc.
Okay.
And there you can also limit, and this is completely justifiable, because I've also heard the argument that if we introduce, let's say, a judicial review, the courts would be submerged with review requests. There can be conditions to check admissibility or the well-founded of a request that can also remedy. So everything needs to be very carefully reflected. Okay. But the main point is to have an effective review. So this is the important thing. And I think this was what was added in the 2024 recommendation from the Commission, to make sure that what we want Cyprus to introduce is an effective remedy and not just a review.
Okay, thank you, Christina. Attorney General?
Thank you very much. Two minor quick points. First of all, I have to express my total disagreement to Mr. Demetriou's suggestion for the legal advisor of the state to be appointed by the president and to be have a
linked with the president's tenure.
That's
yes.
a very dangerous thing, because the legal advisor of the state has to have full independence, and I can assure you, even though people might not see it, the press might not be able to see it, or politicians might not be able to see it, there are numerous instances that we in the law firm give advice which is contrary to what the executive wants us to give. There are many cases that we, respecting and acting on our independence, put forward strongly our legal position and stop matters that want to be done by governments. And let me tell you, we handle a number of thousands of cases of civil claims against the country. Imagine if any president or any, I'm not saying this would happen or might happen, a minister comes to you and says, look, this particular civil case against the state, try to see it in a more favorable manner because we have this sponsor of the government or this guy who has offered this or that. If I believe that my position is dependent on pleasing the government,
yes.
then obviously I don't have the necessary degree of independence to deal with this matter. So under no circumstances the Attorney General's legal advisor should be in any form dependent on the government. Okay. This is point number one. Okay. Point number two, checks and balances. Let me make one thing clear. The fact that the Turkish Cypriots left in 1963 has not affected in any way any checks and balances that relate to the Attorney General's office.
This is a bold statement, Mr. Attorney General. Why you say this?
I say this because in those days, and this is something that I hear a lot, if you read the Constitution and the analysis of the Constitution, you will see that for Turkish Cypriot cases, the sole person that was handling them was the deputy, who was the Turkish Cypriot. And for Greek Cypriots, it was the Greek Cypriot who was the Attorney General. So the fact that we don't have the Deputy Attorney General now, we don't have him as a Turkish Cypriot.
When do we need a deputy?
Sorry, wait, I'll come to that. The fact that we don't have the Turkish Cypriot doesn't mean that there is a fallacy in the checks and balances. The only institution whose checks and balances have been affected is that of the president. Because all appointments, and I agree with Demetris that the president has the rights to appoint everybody.
Yes.
The only person who has lost the checks and balances is the president, because the appointments were made by the president and the vice president. And we don't have vice president now, so one person now decides. Now, going back to the Attorney General, I insist that wherever the Constitution wanted to preserve the joint acting of the Attorney General and the Deputy Attorney General, still exists at the moment, and it is still necessary for the Attorney General and the Deputy Attorney General to agree on those matters, even though the Turkish Cypriots have left. So when it comes to granting pardon by the President, which is an area where both the President, both the Attorney General and the Deputy Attorney General had to agree, we still have to agree.
Yes.
And there have been instances where one of the three has refused, and you are aware that recently when the President wanted to grant pardon,
Yes.
we said, sorry, we're not prepared to agree on that. And that couldn't go ahead.
Yes.
All three of us still have to agree.
And very quickly, your comment on the judicial
On the review.
Yes.
This is a huge issue. We have a whole seminar. I will just say a few things. First of all, we have to make clear that even if we go to judicial review, it will not be a judicial review on the merits. It will be a judicial review on the procedure. So the Attorney General will have to set out the procedure, the criteria, and the considerations that led to his decision, his or her decision, and it is then up to the court to challenge, to revoke it, if proven that the criteria were not correctly followed. If there is a manifest error in the exercise of the discretion, the court has no ability to go through
substitute the discretion.
Substance.
Yes.
The substance. A criminal, there are a few things people have to understand before they make statements which are far-reaching. First of all, do you know how many cases of stopping prosecutions we have every year? We probably have hundreds, if not thousands. There are cases where we have a criminal prosecution of somebody who hasn't paid his social insurances, and then he pays them and he wants to stop the proceedings. We have cases where it's not just the 5, 6, 10 cases that you hear, which are very important, that we have to deal with. So whatever we do, we have to do it in a way that fits the whole ambit of our work. So that's the one thing. The second thing, do you know how many cases of those nolle prosequi actually come to the Attorney General himself?
How many?
Well, very, very few. Very, very few. So if we introduce a hierarchical review like we were intending to do, and like we have already conveyed to the European Commission, I think that it will be a much better review than the judicial review. First of all, because you will have an enlarged panel of people dealing with the review, first. Secondly, it will be a review of substance and not a review of form, which would be the judicial review. And thirdly, we don't need to change the Constitution at all to introduce this. So, for this reason, we went ahead and introduced this procedure. We had to pause because of the
government proposals.
Okay,
thank you,
but
Mr.
I still believe that this is the way forward. There is no way we can present 200 boxes. A serious criminal case could consist of 200 box files of evidence. Would you imagine the courts which are already loaded with work, which are already delaying so much, having 3 Supreme Court judges dealing with reading all these 200 box files and going on the substance of the case? And how is a judge in a position to evaluate the admissibility of evidence, which witness to talk against the other?
So there are many factors to consider.
There are many problems that we have to consider carefully.
Okay, thank you, Mr. Attorney General. Now I will open the floor to the audience, and if we have any questions, and then we wrap up. Yes?
Maybe we'll leave this.
I become muted again.
Hello, my name is Ksenia Mohortova, and I'm a head of Community of Ukrainian Cypriot Friendship. I'm sorry for posing a question outside of the discussion, but it's a question to the Attorney General. As I understand, that the Attorney General is one of the main body who is in charge of enforcing EU sanctions in Cyprus, as I understand, correct? So this is very strange for me to see after 2.5 years of full-scale military invasion in Ukraine that in Cyprus no Russian body is closed. I mean the Russian houses that are propagating Russian war against Ukraine. And just several days ago, they were organizing a celebration of annexed territories on the territory of Cyprus, several kilometers from the occupied territories of Cyprus, a celebration of annexation. They're inviting Russian militaries to have speeches to the teenagers.
I'm sorry, Xenia, your
Yes,
question is out of context, I'm afraid, and I
yes,
will not allow it because it is totally out of subject. We are discussing
It
the
is a
Attorney
question to the
You
Attorney
cannot
General,
use
and
this
his
oppor-
name
No,
is
no,
on
no,
the,
no.
on the
Please,
name of the
please.
panel.
I
So,
apologize,
thank you
but
so much for not letting me
this
ask
is
a question.
inappropriate, I'm afraid. Anyone else? Any other member, any other questions?
No. I would like to go.
No? Okay. Lito?
Shall I address you in English or in Greek? What?
In English, I think it's better.
Right. Well, I was very happy to hear the Attorney General mentioning that for any decision concerning not prosecuting, there's a file with elaborate reasoning. And I'm wondering, is there an objection in disclosing this file and the reasoning? I mean, you did mention that the prosecutors do mention in courts whenever they do announce and prosecute the reasons. However, in my experience, the reasons announced in court are often not satisfying, let's say, to the rights of the victims to hear a reasoned response. So I'm wondering, is there an objection in sort of disclosing this to victims? And full disclosure, of course, I'm representing somebody and I've requested such files with such reasoning before receiving negative answers and eventually having, Strasbourg, of course, sort of disclosing these files in the form of communication to the government of an individual application. But I'm wondering, as a matter of policy and principle, yeah.
Okay, thank you, Lido. Anyone else?
There are a number.
Okay.
Can you hear me now, or do I need to?
You will get the microphone, and we are going for closing remarks.
There are a number of reasons that not every case can go to be communicated either in public or in court or to the public. We try to be as transparent as possible, but I have to make clear that criminal investigations and transparency are a contradiction in terms. Everybody speaks of transparency. There is no way we can ever agree to disclose the evidence we have, the people who actually went out of their way to give a criminal statement in criminal proceedings, and expose them to the public by allowing them to become vulnerable to the victim and realizing why the decision has or not been taken to prosecute. I know that there have been cases where we have not given the reasons for non-prosecution. As I said, our obligation under the Greco evaluation was to make sure that the decision is written in detail in the file of the case. And I can assure you that this procedure is followed, and it has a whole hierarchy of lawyers dealing with this case, each putting his own comments, and at the end of the day, the decision can be reversed or can be approved or whatever. In important cases, we appreciate that the public need to know why we have decided not to prosecute. And even though journalists and politicians, or some journalists and some politicians, want to criticize us that we are not transparent and we don't explain, I can assure you that we have extensive reports leading to our decision in most major cases that caused the
Public discussion,
And,
okay.
Christophoros,
Yeah.
those who are interested to know it, we don't go out having a spokesman in every television station explaining
Understood.
again and again the
Okay.
whole thing. This may be a mistake, I don't know, maybe we have to review this, maybe
Okay.
we have to be more exposed in the media so that our message goes clearer
Thank
to the
you.
public. There are also cases that we have chosen not to give the reasons for prosecution in public when lawyers disagreed with us and said that they wanted to institute private prosecutions in cases where we said that we wouldn't institute public prosecutions. We have written extensive letter to the lawyer of the complainant, explaining to him or her why we
Yes.
reached that conclusion. And we have been criticized by the public for not making this public. Well, there is a very simple reason. We told them if you want to start private prosecution, start it. We're not going to stop it exercising our right to stop prosecution. Go ahead and do it. But we believe you will not succeed. But if you want to try, try. Now, if I go in public and I tell everybody the reasons that led to my decision not to prosecute,
Yes.
then obviously I will be putting the defense of that person
Yes, yes.
should a private prosecution be instituted. And we didn't think it was fair to do that.
Thank you, Mr. Attorney General. Christina, let's close with your final remarks. Perhaps a couple of points you want to highlight.
Well, to bring something extra in the discussion, future discussion, there are also countries that have a mixed review system, both judicial and hierarchical, just to food for thought. I would like just to say that the European Commission welcomes the efforts by Cyprus to respond to the recommendation and also the ongoing discussions, the public debate. So we are looking forward to see how this will evolve. We understand that changes that touches upon sensitive constitutional issues takes longer. So we are not expecting Cyprus to implement the recommendation within a few months. It wouldn't be prudent, exactly. So there should be the necessary reflection, the necessary discussions. And the Commission, of course, is ready to assist Cyprus in this effort. Thank you very much.
Demetri?
Έτσι, πολύ σύντομα και καταληκτικά, να πω πως πολιτικά, τουλάχιστον σε ό,τι μας αφορά εμάς, αντιμετωπίζοντας το όλο ζήτημα, είναι η ώρα, θεωρούμε πως έχουν οριμάσει οι συνθήκες, υπάρχει οριζόντια πολιτική πρόθεση για αλλαγές, για μεταρρύθμιση, για διαχωρισμό του ρόλου του Γενικού Εισαγγελέα και θεωρώ πως είναι η στιγμή, είναι το timing που θα πρέπει να το αξιοποιήσουμε.
Να κινήσει η διαδικασία. Prime Minister, your final remarks, please, and a couple of
What should I
points.
say? I said in my previous voice that it was a discussion on the internal system in Cyprus, yes? So I can sit here as an observer, but finally I can repeat what I said, that the Venice Commission can make only a very general rules, because as we can see, they will license details. And so for that reason, the Venice Commission said that as concerns the prosecutor office, the general pillars should be only regulated on the European level, and details should be regulated by local law, state law, because it is also rooted in the local tradition, so it should be taken into account. But sometimes it is very difficult to define what is a local tradition, because we have countries, I can say in the end, which local tradition is a corruption. So for that reason, probably it's not the good example to follow this example, yes, but exactly in Cyprus is a different country, but you have a different system. You have a system when the prosecutor general was also in a very specific position. So for that reason, it is accepted by the Venice Commission, but then the details of the regulation must be in the framework of the guidelines which are prepared by the Venice Commission. Yes, so it is
Okay,
the
thank you,
crucial
Prime
what I should say.
Minister. Thank you, everybody, for your attention. I know the subject is huge. We
Huge.
have touched upon certain aspects of it. It was a very interesting discussion. Thank you, everybody. Thank you, Attorney General, Christina, Demetris, and Prime Minister.